The client will want to know what is going to happen next after the interview. Remind the client of any scheduled appointments, such as doctor visits or depositions. If there are none, simply tell the client that you will be preparing a report for the attorney on the case and that the office will be getting back to the client. Also summarize anything you asked the client to do during the interview, e.g., call you to provide the exact address of a former employer. Begin preparing a draft of your intake memorandum soon after the interview is over, while the data and your notes are fresh in your mind. See Exhibit 8.3. Do this even if you need to obtain additional facts to include in your memorandum by follow-up interviewing or investigation. Modern word processing makes it relatively easy to make additions to memos or other documents. See Chapter 13. Do not wait until you have all the facts before you start writing. Also make a notation in the client's file that you conducted the interview even before you complete the intake memo. If the file does not have a summary form on which events can be recorded, simply place a brief note in the file stating the date and place of the interview. Someone else in the office, working on the case, e.g. supervising attorney, law clerk, secretary, should be able to pick up the file and tell what has been done to date. For a summary of these and similar steps you need to take at the end of an interview, see Exhibit 8.12 Personality Observations. After conducting an interview, you should formulate some preliminary observations about the client's personality. Here is how one attorney described this aspect of the interview. Assess the client's personality and whether you think the office can work with this person. Watch for red flags or danger signals, including the client who is emotionally distraught or vengeful, is inconsistent with the story, or avoids answering questions, has unrealistic objectives, suggests use of improper influence or other unethical or illegal conduct, rambles, wanders off the subject, or constantly interrupts you, tells the office how to run the case, has already discharged or filed disciplinary complaints against other lawyers, has a personality disorder, or is flirtatious. In your intake memorandum to your supervisor, include your observations and assessments relevant to concerns such as these. Improving your interviewing skills. There are many ways you can improve your interviewing skills. They are summarized in Exhibit 8.13. Be a perpetual student of the law. Always be inquisitive. Never be totally comfortable with any of your skills. One of the fascinating aspects of working in a law office is the availability of infinite opportunities to grow and improve. Exhibits 12. Ending the interview. Ask the client to sign any standard forms needed by the office, e.g. consent to release medical information, authorization to obtain employment history records. Before doing so, clearly explain what the document is designed to do and give the client the opportunity to ask any questions about the document before he or she signs it. Ask the client if there is anything else on his or her mind that he or she would like to raise before the interview is concluded. Let the client know precisely what the next step will be in the office's representation of the client, e.g. the attorney will call the client, the paralegal will schedule a medical examination of the client. Remind the client how to reach you. Have additional copies of your business card on the desk. Thank the client for the interview. Start preparing a draft of your intake memorandum. In the client's file, make a brief note of the fact that you conducted the interview. Include the date and place of the interview. Improving your interviewing skills. There is a good deal of literature on legal interviewing. Check legal periodicals and legal treatises. Ask a law librarian for leads to such literature. See also Exhibits 11.35 and 110.38 in Chapter 11. Try to attend seminars that cover legal interviewing, e.g. CLE continuing legal education, seminars for attorneys conducted by bar associations, or CLE seminars conducted by paralegal associations. Ask someone you respect in the office to observe you interview a client and then give you a critique. You will need the advance permission of the client for this person to sit in. Ask someone you respect in the office to read your intake memorandum and critique it. An experienced interviewer will be able to see if there appear to be any gaps in what you covered in your memorandum. Try to sit in when others in the office are interviewing clients. Read their memorandum on the interview, and ask them questions about their interviewing techniques. To observe someone else's interview, you will need the consent of the interviewer and of the client interviewee. Ask attorneys and other paralegals about their interviewing experiences even if you are not able to watch them conduct an interview. The difficult client. Most clients are relatively easy to work with. Occasionally, however, you will encounter clients who can be troublesome. Here are some examples. The client who knows all the law. Some clients are quick to tell the office that they know the law. They may have been in litigation before, have taken courses on law, have a close relative who is an attorney, or have read a good deal about the law on the internet. The difficulty arises if such clients are always second-guessing the way the office is handling their case, or are unduly critical of anyone trying to help them. Ultimately, the attorney in charge of the case must decide if the office can continue to work with such clients. All clients, of course, are entitled to their opinions about the legal system and about anyone trying to help them. The central question is whether a client is prepared to listen to the advice provided by the attorney. The client is not obligated to follow every recommendation, but there may be no point in continuing with the attorney-client relationship if the client does not trust the attorney's professional judgment. Paralegals working with such clients must be careful to avoid arguing with them or giving them legal advice. If a client starts lecturing a paralegal about the law, the best response is to listen respectfully and then respond by saying, "I'll be sure to let the attorney know what you have said." The angry client. Some clients can be very angry. They may feel outrage at the injustice someone has allegedly committed against them. It is important that such clients be given a chance to express themselves. At the very least, they need to know that the office they have hired understands what they have been through and how they feel. They need an opportunity to vent. If, however, they continue to be angry after they have had this opportunity, the office may have difficulty providing them with effective representation. As indicated earlier, it is important to show empathy for a client by making comments such as, "This must be a very difficult time for you," or "I can understand why that would be upsetting." These comments can have a settling effect on clients without immersing the interviewer into the middle of an emotional thicket. You do not want to lose your professionalism by adopting the same pessimistic or hostile frame of mind as the client. The demanding/suspicious client. Some clients have difficulty believing that everyone in the office is not preoccupied with their case. They demand instant attention and results. "Why is it taking so long? I want this thing over." They may interpret delays as a tactic by the office to run up fees. An obvious response is to explain that the courts and the legal system often work at a very slow pace unless an extreme emergency exists. Generally, it is not very helpful to point out that there are other clients who also need the attention of the attorneys and paralegals in the office. One possibly effective approach is to keep demanding clients constantly informed of the status of their case. Mail them copies of documents as these are prepared for them, and send them a periodic report on the status of their case. During the initial interview, the office needs to head off or offset any unrealistic client expectations about how much time the case will take by providing a time range such cases often take for completion. The client also needs to be told that complications, e.g., new counterdemands by the opponent, almost always create additional delays. The client who lies. There is a difference between clients who gi/e facts a favorable interpretation and clients who lie. Assume, for example, that an office represents a husband who is seeking sole custody of his children in a bitter divorce case. It is understandable that he will attempt to portray himself as a loving father. He may glowingly describe the positive effect he has had on his children by attending sports events with them and by helping them with their homework. Careful questioning and further investigation will help determine whether he has exaggerated his role. If he has, an experienced legal team will know how to present his case in a favorable light without compromising the truth. Suppose, however, that the father goes beyond exaggeration. For example, he may falsely claim that he does not use corporal punishment on the children, or he may deny that he takes illegal drugs in front of them in spite of evidence to the contrary. Of course, if any of these facts can reasonably be interpreted in the father's favor, the office has an obligation to present this interpretation to the court. Yet it may eventually become clear to the office that the client has a tendency to lie. Serious ethical problems can arise in such cases. As we saw in Chapter 5, an attorney has an ethical obligation to avoid telling the court something that is not true, and to avoid allowing a client to lie to the court when the attorney knows that this is what the client has done or is about to do. An attorney/is withdrawal from a case is justified when continued representation of the client will cause the attorney to violate an ethical obligation. Furthermore, it may be impossible for the attorney to provide competent representation without knowing all available facts. The client must be told that the attorney cannot rebut negative facts without knowing what those facts are. The client cannot make those facts go away by lying about them or concealing them. If the office cannot convince the client of this reality, the likelihood of representing the client effectively and ethically is very low. Class Exercise 8.c Form a circle of chairs, with a single chair in the middle. The student sitting in the middle will play the role of the client. The students in the circle numbering about 10 will be the interviewers, in rotation. The instructor will ask one of the students to begin the interview. As this student runs into difficulty during the interview, the student to his or her right picks up the interview, tries to resolve the difficulty in his or her own way, and then proceeds with the interview. This student cannot resolve the difficulty, the student to his or her right tries, and so on. The objective is to identify as many diverse ways of handling difficulties as possible in a relatively short period. No interviewer should have the floor for more than a minute or two at any one time. The student playing the role of the client is given specific instructions about how to play the role. For example, sometimes he or she is asked to be shy, other times demanding. The client should not overdo the role, however. He or she should respond naturally within the role assigned. Here are 4 sets of instructions to attempt this interview in rotation. The interviewer greets the client and says, "I am a paralegal." The client is confused about what a paralegal is. The interviewer explains. The client is insistent upon a comprehensive definition that he or she can understand. The client comes to the law office because he or she is being sued for negligent driving. The interviewer asks the client if he or she must wear eyeglasses to drive. The answer is yes. The interviewer then asks if he or she was wearing eyeglasses during the accident. The client is very reluctant to answer. In fact, the client was not wearing glasses at the time. The client does not appear to want to talk about this subject. The interviewer persists. The client is being sued by a local store for $750 in grocery bills. The client has a poor memory, and the interviewer must think of ways to help him or her remember. The client wants to cooperate but is having trouble remembering. The client wants to sue an auto mechanic. The client gives many opinions, conclusions, and judgments such as the mechanic is a crook, I was their best customer, the work done was awful. The interviewer is having difficulty encouraging the client to state the facts underlying the opinions. The client insists on stating conclusions. After each exercise, the class should discuss principles, guidelines, and techniques of interviewing. Class Exercise 8. Below are 2 additional role-playing exercises to be conducted in class. The instructor asks the class if anyone was involved, in any way, in a recent automobile accident. If someone says yes, this student is asked if he or she would be willing to be interviewed by another class member, whose job is to obtain as complete a picture as possible of what happened. At the outset, the interviewer knows nothing other than that some kind of an automobile accident occurred. The interviewee can make up any sensitive facts if he or she wishes to keep some of the actual events confidential. The instructor asks the class if anyone has recently had trouble with any government agency like the post office or sanitation department. If someone says yes, this student is asked if he or she would be willing to be interviewed by another class member, whose job is to obtain as complete a picture as possible of what happened. The interviewer at the outset knows nothing other than the fact that the person being interviewed has had some difficulty with a government agency. The interviewee can make up any sensitive facts if he or she wishes to keep some of the actual events confidential. Class Exercise 8.E. When an office represents a debtor, one of the paralegal's major responsibilities may be to interview the client in order to write a comprehensive report on the client's assets and liabilities. Assume that your supervising attorney has instructed you to conduct a comprehensive interview of the client in order to write such a report. Assets are everything the client owns or has an interest in. Liabilities are everything owed. They are debts. These are the only definitions you need. You do not need any technical knowledge of law to conduct this interview. All you need is common sense in the formulation of questions. Your instructor will role-play the client in front of the room. It will be a collective interview. Everyone will ask questions, but you will each write individual reports on the interview, based on your own notes. Raise your hand to be recognized. Be sure to ask follow-up questions when needed for factual clarity and comprehensiveness. You can repeat the questions of other students if you think you might elicit a more detailed response. Any question is fair game, as long as it is directly or indirectly calculated to uncover assets or liabilities. There may be information the client does not have at this time, such as bank account numbers. Help the client determine how such information can be obtained later. In your notes, state that you asked for information that the client did not have, and state what the client said he or she would do to obtain the information. To achieve comprehensiveness, you must obtain factual detail. This means that you go after names, addresses, phone numbers, dates, relevant surrounding circumstances, verification data, etc. In short, we want fact particularization FP. See also Exhibit 8.10. Take detailed notes on the questions asked by every student, not just your own, and the answers provided in response. You will have to write your report based on your own notes. The heading of your report will be as follows: Inter-Office Memorandum to left bracket name of your instructor, right bracket from left bracket your name, right bracket date, left bracket date you prepared the report, right bracket Ray. Comprehensive interview of case file number. Make up the case file number. The first paragraph of your report should state what your supervisor has asked you to do in the report. Simply state what the assignment is. Organization of the data from your notes is up to you. Use whatever format you think will most clearly communicate what you learned from the client in the interview. Chapter 2 of MER Carat projecting competence and professionalism is an essential ingredient in performing any task on behalf of a client. The retainer establishes the scope of the attorney-client relationship. If the office decides not to represent the prospective client, it should send him or her a letter of non-engagement. Interviewing is conversation for the purpose of obtaining information. In a law office, legal interviewing is designed to obtain facts that are relevant to the identification and even to all resolution of a legal problem. These facts are often reported in a document called an intake memo. 6 major guides exist to the kinds of questions that should be asked during a legal interview. The most important is the instructions of the supervisor on the goals of the interview. Other guides include pre-printed checklists for certain kinds of interviews, legal analysis to help you focus on relevance, fact particularization as a device to achieve comprehensiveness, and finally, common sense and flexibility to help you remain alert and responsive as the interview unfolds. Determining what the client wants often takes probing and presentation of options. Otherwise, the office might fail to identify client objectives. Most of us are not fully aware of how our prejudices affect our performance. Detecting interviewer bias may not be easy. It is sometimes difficult to distance our personal feelings from the client's objectives. The supervising attorney helps set the tone for an effective interview by introducing the client to the paralegal and explaining the latter's role. The professional interviewer strives to uncover facts that make the case of each client unique. There are many ways to prepare for an interview, such as scheduling the interview at a convenient time, reading everything in the file, having supplies available, and preparing initial questions. The seating arrangement should facilitate communication. The walls, desk, and overall appearance of the office should project a professional image. Go out to greet the client when he or she arrives at the reception desk. Always be appreciative of what the client does. Some small talk at the beginning of the interview can help decrease client tension. Avoid making any promises of what the office can accomplish. Express empathy without being condescending or losing objectivity. Find out if there are any immediate concerns on the client's mind. Avoid legal jargon unless the client needs to know about it and clear explanations are given. Briefly restate the purpose of the interview for the client. Let the client know why you are taking notes. Listen for clues to other problems the office should know about. The following are the major kinds of questions an interviewer can ask, some of which overlap. Open-ended overview, closed-ended chronological, leading corroborative, and combination. One of the most important ways of building a relationship with the client is through attentive listening techniques, such as maintaining eye contact and repeating back what the client has told you. Factual comprehensiveness is achieved through fact particularization, corroborative questions, probing, etc. The interviewer must be alert to potential ethical problems such as breaching confidentiality and giving legal advice. At the conclusion of the interview, ask the client to read and sign needed forms. Find out if the client has any concerns not addressed during the interview. Tell the client what next steps are planned and make sure the client knows how to reach you. As soon as possible, make a note to the file that you conducted the interview. Begin writing the report or intake memo soon after the interview, making note of any personality characteristics relevant to working with the client that you observed. To improve your interviewing technique, read literature and attend CLE seminars on interviewing, seek the critique of others, try to observe others' interview, etc. Special sensitivity is needed when working with potentially difficult clients such as those who claim to know all the law, who are angry, who are demanding, or who lie. Every effort should be made to work with such clients while maintaining professionalism, but ultimately the office may have to decide whether continued representation is feasible or ethically appropriate. Key terms: retainer, deep pocket letter of non-engagement, intake memo, ray ground, legal analysis, legally relevant fact particularization, analogy, bias, objectivity, hypothetical, breach of contract, jargon, open-ended question, overview question, closed-ended question, chronological question, leading question, corroborative question, combination question, multiple choice question, add-on question, attentive listening on the net. More about interviewing. Selected articles: www.rongolini.com/interviewing.html. Legal interviewing. Difficult clients: www.kua.edu/faculty/barry/articles/binder12.htm. Resources on client interviewing: www.mulofsociety.internet.co.uk/client interviewing/reading.html. Endnotes. 1. Brent Roper, Practical Law, Office Management, 121-1995. 2. Shari Kadran, Crisis of Conscience, 12 Legal Assistant Today, 73-75 September/October 1994. 3. William P. Statsl Y. Philip C. Lang, The Legal Paraprofessional as Advocate and Assistant. Roles, Training, Concepts, and Materials, Center on Social Welfare Policy and Law, 1971. 4. Denise Clemens, Client Interviewing, 1 California Paralegal Magazine, 12-13 October/December 1991. 5. See also White, Architectural SUCARETESTIONS for a law office building, 9 Practical Lawyer 66 No. 81956. 6. H. Freeman H. Y. Huffin, Clinical Law Training, Interviewing and Counseling M. 972 yen. 7. The Initial Interview, 1-2 Family Advocate, 6 Winter 990. Chapter 9 Investigation. In a law office chapter, outline A. The nature and context of investigation. B. Fact analysis. Organizing the options. C. Distortions in investigation. D. Sources of evidence / sources of leads. E. Gaining access to records. F. Evaluating evidence. G. Interviewing witnesses. H. Special investigative problems. Some starting points: I. Evidence and investigation. J. Taking a witness statement. K. The settlement workup. R. Legal investigation, the process of gathering additional facts and verifying presently known facts in order to advise a client about solving or avoiding a legal problem. Forensic, pertaining to the use of science to help resolve a legal question, used in arguments or public debate. Sectus in ATLII nature and context. LW investigation. Legal investigation is the process of gathering additional facts and verifying presently known facts in order to advise a client about solving or avoiding a legal problem. Our study of investigation will focus on three main topics: the nature of investigation, the techniques of investigation, and evidence law relevant to investigation. In many law offices, paralegals are often called upon by attorneys to track down important information that is relevant to a real estate transaction, a corporate transaction, a case that is in litigation, or a case where litigation is anticipated. Lana Clark, a litigation paralegal, says many of us have been approached by our attorneys at the last minute to interview a witness and find out what he knows. For large cases, a law firm might use an outside licensed private investigator, or perhaps an investigator with a specialty, e.g. a forensic accountant, who will examine corporate records for evidence of fraud or embezzlement. In the movie Erin Brockovich, based on a true story, Julia Roberts won an Academy Award for her role as a non-attorney employee who was given a major investigation assignment in the law office where she worked. She investigated the link between a highly toxic antitrust chemical agent chromium-6 used by a major public utility and the life-threatening diseases suffered by residents in the area where the utility had dumped the agent. Their water supply had become contaminated. Brockovich's work led to a $333 million settlement for the victims and eventually to a $1 million bonus for herself from her grateful supervising attorney. Of course, most paralegal investigation assignments will not be this dramatic. Yet the movie certainly highlighted the importance of investigation and the critical role that non-attorneys can have in this arena of fact-gathering. In Chapter 8 on legal interviewing, we examined 6 major guides to fact-gathering. Instructions of the supervisor, checklists, legal analysis, fact particularization, FP. Common sense, flexibility. You should review these guides now because they are equally applicable to investigation. Fact particularization, FP, is especially important. We begin our study of legal investigation with some general observations about its nature and context. 1. Investigative techniques are often very individualistic. Styles, mannerisms, and approaches to investigation are often highly personal. Through a sometimes arduous process of trial and error, the investigator develops effective techniques. Some of these techniques come from the suggestions of fellow investigators. Most, however, are acquired from on-the-job experience too. It is impossible to overemphasize the importance of hustle, imagination, and flexibility. If there is one characteristic that singles out the effective investigator, it is a willingness to dig. Many investigation assignments are relatively straightforward. For example, check court records to find out if a particular doctor has any other malpractice cases pending against him or her. Find out if someone has filed a workers' compensation claim. Obtain a copy of an ambulance report. Photograph the ceiling of a bathroom that a tenant claims is falling down. Other assignments are potentially more involved because they are open-ended, e.g., find out what property or other assets of the defendant may be available to pay a judgment. An extensive range of options and conclusions is possible in such assignments. The answer is not always there for the asking. For such assignments, investigators must be prepared to identify and pursue leads, be unorthodox, and let their feelings, hunches, and intuition lead where they will. In short, the formal principles of investigation must give way to hustle, imagination, and flexibility. Good investigators are always in pursuit. They are on the offensive and do not wait for the facts to come to them. They know that legwork is required. They know that 50% of their leads will turn out to be dead ends. They are not frightened by roadblocks, and therefore do not freeze at the first hurdle. They know that there are no perfect ways of obtaining information. They know that they must take a stab at possibilities and that it takes persistent thinking and imagination to come up with leads. At the same time, good investigators are not fools. They do not pursue blind alleys. After being on the job for a while, they have developed a feel for whether a possibility or lead is reasonable. They have been able to develop this feel because when they first started investigating, they had open minds and were not afraid to try things out. 3. Investigators may not know what they are looking for until they find it. Investigation, like interviewing and legal research, sometimes takes on a life of its own, particularly in open-ended assignments, where you may be walking into the unknown. You may not know what you are looking for until you find it. Suppose, for example, that the law firm has a client who is charging his employer with racial discrimination. In the process of working on the case, the investigator discovers that this employee had a managerial job at the company, and that several of the workers under him have complained that he practiced racial discrimination against them. The investigator had no idea that she would uncover this until it was uncovered. In short, an open mind is key when undertaking an assignment. 4. Investigation and interviewing are closely related. The interviewer conducting the initial client interview has two responsibilities: to help identify legal problems, and to obtain from the client as many relevant facts on those problems as possible. The starting point for the investigator is the report or intake memo, see Exhibit 8.3, prepared by the interviewer, on what the client said. The investigation needs may be clear from this report, or they may become clear only after the investigator and his or her supervisor have defined them more precisely. The investigator should approach the interview report with a healthy skepticism. Thus far, all the office may know is what the client has said. The perspective of the office is therefore narrow. Without necessarily distrusting the client's word, the investigator's job is to verify the facts given during the interview, and to determine whether new facts exist that were unknown or improperly identified during the interview. The interview report should not be taken at face value. New facts may be revealed, or old facts may for the first time be seen in a context that gives them an unexpected meaning. The investigator must approach a case almost as if the office knows nothing about it, or as if what the office knows is invalid. By adopting this attitude, the investigator will be able to give the case an entirely different direction when the product of the investigation warrants it. 5. The investigator must be guided by goals and priorities. It is one thing to say that the investigator must be open-minded enough to be receptive to the unexpected. It is quite another to say that the investigator should start in a void. The starting point is a set of instructions from the supervisor. How clear a supervisor is about an investigation assignment may vary with each assignment. For example, supervisors may have a very definite idea of what they want. Supervisors may think they know what they want but are not sure. Settlement: an agreement to end a dispute before it is resolved by all available agencies or courts impeached to challenge. To attack the credibility of discovery: compulsory, pre-trial disclosure of information by one party and its prospective witnesses to another party during litigation. Deposition: a method of discovery by which parties and their prospective witnesses are questioned before trial. A pre-trial question and answer session to help parties prepare for trial. Interrogatories: a method of discovery consisting of written questions sent by one party to another to assist the sender to prepare for trial. Request for admission: a method of discovery consisting of a statement of fact that the other side is asked to affirm or deny. Whatever conception supervisors have about what they want, they are not effective in explaining it to the investigator. Supervisors have no idea what they want other than a desire to obtain as many facts about the case as possible. The first responsibility of the investigator is to establish communication with the supervisor with as much clarity as possible, determine what the supervisor wants to accomplish through the investigation. Investigation, negotiation, and trial are closely related. There are two ultimate questions that should guide the investigator's inquiry into every fact being investigated. How will this fact assist or hurt the office in attempting to settle or negotiate the case without a trial? How will this fact assist or hurt the office in presenting the client's case at trial? A large percentage of legal claims never go to full trial. Opposing counsel hold a number of bargaining sessions, in which they attempt to hammer out a settlement acceptable to their clients. Very often they discuss the law that they think v/ill be applicable if the case goes to trial. Even more often they present each other with the facts that they think they will be able to establish at trial. Here, the investigator's report becomes invaluable. As a result of this report, the attorney should be able to suggest a wide range of facts that could be used at trial. We have reason to believe, or we are now pursuing leads that would tend to establish that, etc. The attorney's bargaining leverage is immeasurably increased by a thorough investigation report. If negotiations do not produce a settlement, the investigator's report can help the attorney determine whether to go to trial, decide what witnesses to call, choose questions to ask of witnesses, decide how to impeach, i.e. contradict or attack the credibility of opposing witnesses, anticipate how the other side might try to impeach your client and witnesses. Determine what tangible or physical evidence to introduce, decide how to attack the tangible or physical evidence the other side will introduce. The investigator should be familiar with the standard pre-trial discovery devices: depositions, interrogatories, requests for admissions, medical examination reports, etc. See Exhibit 10.4 in Chapter 10. A deposition is a pre-trial question and answer session, conducted outside court, usually in the office of one of the attorneys. The attorney asks questions of the other party or of a witness of the other party, in order to obtain facts that will assist in preparing for trial. Depositions are often transcribed so that typed copies of the session are available. Interrogatories are used for the same purpose, but differ in that the questions and answers are usually provided in writing rather than in person. An interrogatory is simply a question submitted by one party to another. A request for admission is a statement of fact submitted by one party to another. The latter is asked to admit or deny the statement. Statements that are admitted do not have to be proven at trial. A request for a medical examination will be granted by the judge when the examination will help resolve a medical issue in the trial. Investigators can be of assistance during this discovery stage by helping the attorney decide what questions to ask in a deposition or in an interrogatory, what admissions to request, whether to ask for a medical examination, etc. After the discovery devices have been used, the investigator should carefully study all the facts these devices disclose in order to cross-check or verify these facts and look for new leads, names, addresses, incidents that could be the subject of future investigation. 7. It is important to distinguish between proof of a fact and evidence of a fact. Evidence is anything that tends to prove or disprove a fact. Proof is enough evidence to establish the truth or falsity of a fact. Investigators are looking for evidence. They should not stop looking simply because they have not found proof. It is the role of the judge and jury to determine truth and falsehood. The function of investigators is to identify reasonable options or fact possibilities. To be sure, they can speculate on whether a judge or jury would ever believe an alleged fact to be true. But the presence or absence of proof is not the test that should guide them in their investigations. The tests that an investigator should apply in determining whether to investigate a fact possibility are: am I reasonable in assuming that a particular fact will help establish the case of the client? Am I reasonable in assuming that the specific evidence of that fact I am investigating might be accepted as true by a judge, jury, or hearing officer? Am I reasonable in assuming that a particular fact will help to challenge or discredit the case of the opposing party? Am I reasonable in assuming that the specific evidence of that fact I am investigating might be accepted as true by a judge, jury, or hearing officer? It is important to be able to approach the case from the perspective of the opponent, even to the point of assuming that you work for the other side. What facts will the opponent go after to establish its case? What is the likelihood that such facts will be accepted? 8. The investigator must know some law. Investigators do not have to be experts in every area of the law or in any particular area of the law in order to perform their job. for their field work to have a focus. However, they must have at least a general understanding of evidence, civil procedure, and the areas of the law governing the facts of the client's case. They must know, for example, what hearsay and relevance mean. They must understand basic procedural steps in litigation in order to see how facts can be used in different ways at different steps in the litigation process. Some substantive law is also needed. In a divorce case, for example, the investigator must know what the grounds for divorce are in the state. The same kind of basic information is needed for every area of the law involved or potentially involved in the client's case. Such knowledge can be obtained in paralegal courses or seminars through brief explanations from the supervisor, by talking to experienced attorneys and paralegals whenever they have time to give you an overview of the relevant law, by reading a chapter in a legal treatise or a section in a legal encyclopedia that provides an overview of the relevant law. See Exhibit 11.18 in Chapter 11 on techniques for doing background research on a topic. 9. The investigator must know the territory. When you are on the job as an investigator, it is important to begin acquiring a detailed knowledge of the makeup of the city, town, or state where you will be working. Such knowledge should include the political structure of the area. Who is in power? Who is the opposition? In what direction is the political structure headed? The social and cultural structure of the area. Are there racial problems? Are there ethnic groupings that are diffused or unified? Are there different value systems at play? The contacts that are productive. If you want something done at City Hall, whom do you see? What court clerk is most helpful? Does the director of a particular agency have any control over the staff? What agencies have real services available? It is usually very difficult for the investigator to acquire this knowledge in any way other than going out into the field and obtaining it through experience evidence. Anything that tends to prove or disprove a fact, proof enough evidence to establish the truth or falsity of a fact. Others can provide guidance, and often will. In the final analysis, however, you will probably discover that what others say is biased or incomplete. You must establish your own network of contacts and sources of information. First and foremost, you must establish your credibility in the community. People must get to know and trust you. Simply announcing yourself as an investigator or presenting a printed card indicating title and affiliation will not be enough to win instant cooperation from the community. You must earn this cooperation. If you gain a reputation as arrogant, dishonest, opportunistic, or insensitive, you will quickly find that few people want to deal with you. An investigator could be in no worse predicament. Often the best way to learn about an area and begin establishing contacts is by being casual and unassuming. Have you ever noticed that insurance agents often spend time talking about the weather, sports, politics, the high cost of housing, etc. before coming to their sales pitch? Their intent is to relax you, to find out what interests you, to show you that they are human. Then they hit you with the benefits of buying their insurance. The investigator can use this approach, not only in establishing contacts at agencies and in the community generally, but also in dealing with prospective witnesses on specific cases. Section B. Fact analysis. Organizing the options. The process of structuring or organizing fact options may initially appear to be complex and cumbersome. But the process can become second nature to you once you understand it, try it out, evaluate it, modify it, and find it helpful. It is, of course, perfectly proper to adopt any process that you find effective. Whatever method you use, you need to develop the discipline of fact analysis as soon as possible. A number of fundamental characteristics of facts should be kept in mind. Events take place. Events mean different things to different people. Different people, therefore, can have different versions of events. Inconsistent versions of the same event do not necessarily indicate fraud or lying. Although someone's version may claim to be the total picture, it probably will contain only a piece of the picture. In giving a version of an event, people usually mix statements of why the event occurred with statements of what occurred. Or worse, they may tailor their description of what happened to fit their version of why the event occurred. Whenever it is claimed that an event occurred in a certain way, one can logically expect that certain signs, indications, or traces evidence of the event can be found. Given these truisms, the investigator should analyze the facts along the lines indicated in Exhibit 9.1. It is possible for a single client's case to have numerous individual facts that are in dispute. Furthermore, facts can change, or people's versions of facts can change in the middle of a case. Each new or modified fact requires the same comprehensive process of fact analysis outlined in Exhibit 9.1. Of course, every fact will not necessarily have multiple versions. It is recommended, however, that you assume there will be more than one version until you have demonstrated otherwise to yourself. Obtaining different versions of a fact is sometimes difficult because the differences may not be clear on the surface. Undoubtedly, you will have to do some probing to uncover the versions that exist. Better to do so now than to be confronted with a surprise at trial or at an agency hearing. People will not always be willing to share their accounts or versions of facts with you. If you are not successful in convincing them to tell their story, you may have to make assumptions of what their story is likely to be, and then check out these assumptions. Fact analysis in investigation. Starting point. All the facts you currently have on the case. Arrange the facts chronologically. Place a number before each fact that may have to be established in a legal proceeding. State the following versions of each fact. Version I. The client's version II. The opponent's as revealed to you, or as assumed, version III. A witness's version IV. Another W/witness's version V. Any other reasonable version, e.g., from your own deductions, as to each version. State precisely with quotes if possible, what the version is. State the evidence or indications that tend to support the version according to persons presenting the version. State the evidence or indications that tend to contradict this version. Determine how you will verify or corroborate the evidence or indications. Section C. Distortions. In instigation, investigators are not mere newspaper reporters or photographers who simply report what they see, hear, or otherwise experience. You have a much more dynamic role. In a very significant sense, you sometimes have the power to influence what someone else says about the facts. This can have both positive and negative consequences. Be alert to the danger of asking questions in such a manner that you are putting words into the person's mouth. The primary technique that can bring about this result is the leading question. A leading question is one that suggests an answer in the statement leading question, a question of the question. For example, you were in Baltimore at the time, isn't that correct? You. That suggests an answer in earn over $200 a week. Would it be correct to say that when you drove up to the curb, the question, you didn't see the light? For more on the different kinds of questions that can be asked, see Exhibit 8.8 in Chapter 8. Questions can intentionally or unintentionally manipulate someone's answer by including a premise that has yet to be established. It takes an alert person to say to such questions, I can't answer your question, or it is invalid, because it assumes another fact that I haven't agreed to. In the following examples of questions and answers, the person responding to the question refuses to be trapped by the form of the question. Q. How much did it cost you to have your car repaired after the accident? It's not my car, and it wasn't an accident. Your client deliberately ran into the car that I bore. Road. Q. Have you stopped beating your wife? I never beat my wife. Q. Can you tell me what you saw? I didn't see anything. My brother was there, and he told me what happened. The last leading question, containing the unestablished premise, can be highly detrimental. Suppose the question and answer went as follows. Q. Can you tell me what you saw? The car was going about 70 mph. In fact, the person answering the question did not see this himself. His brother told him that a car was traveling at this speed. This person may have failed to tell the investigator that he did not see anything firsthand for a number of reasons. Perhaps he did not hear the word saw in the investigator's question. He may have wanted the investigator to think that he saw something himself. He may want to feel important by conveying the impression that he is special because he has special information. He may have felt that correcting the investigator's false assumption was not important. He may have thought that the investigator was more interested in what happened than in who saw what happened. Perhaps he did not hear the word saw in the investigator's question. He may have wanted the investigator to think that he saw something himself. He may want to feel important by conveying the impression that he is special because he has special information. He may have felt that correcting the investigator's false assumption was not important. He may have thought that the investigator was more interested in what happened than in who saw what happened. Whatever the reason, the investigator has carelessly put himself or herself in the position of missing a potentially critical fact, namely that the person is talking from hearsay. Before asking what the person saw, the investigator should ask, "Were you there? And if so, did you see anything?" Also be careful about the way you phrase a question. Research indicates the wording of questions to witnesses significantly affects their recall. For example, more uncertain or don't know responses are given if a witness is asked about an indefinite item, e.g., "Did you see a knife?" then occurs when the question contains a definite article, "Did you see the knife?" Communication is often blurred when the questioner concentrates on some themes to the exclusion of others. If you do not ask questions about certain matters, intentionally or otherwise, you are likely to end up with a distorted picture of a person's version of the facts. For example, assume that Smith and Jones have an automobile collision. The investigator, working for the attorney who represents Jones, finds a witness who says that she saw the accident. The investigator asks her to describe what she saw, but fails, however, to ask her where she was at the time she saw the collision. In fact, she was sitting in a park more than 2 blocks away and could see the collision only through some shrubbery. The investigator did not ask questions to uncover this information. It was not volunteered. The investigator therefore walks away with a potentially distorted idea of how much light this individual can shed on what took place. This is similar to the distortion that can result from the use of questions that contain an unestablished premise, yet in some instances these techniques may have beneficial results. First of all, a leading question can help jar someone's memory, making the person better able to recall the facts. If, however, this person constantly needs leading questions in order to remember, you have strong reason to suspect that, rather than being merely shy, inarticulate, or in need of a push now and then, the person knows little or nothing. Suppose that the witness being questioned is uncooperative, or has a version of the facts that is damaging to the client of the investigator's office. It may be that the techniques described in this section, as normally improper, can be used to challenge a version of the facts. A leading question, with an unestablished premise, for example, may catch an individual off guard, and give the investigator reasonable cause to believe that the person is not telling the truth. If you have reason to doubt someone's willingness to tell you what he or she knows, a leading statement or question might be helpful in prompting communication. A technique I've found very successful is to ask a question I feel will evoke a factual answer. For example, I would ask Mr. John Doe, "Mr. Doe, you claim that you are a witness to the accident when in fact, I understand you are not in a position to see everything that happened." Often the person will respond with a defensive answer similar to, "I was in a position to see everything," and then continue to tell me their location and what they saw. Suppose that the person being questioned is not hostile, but is neutral, or seemingly so. The way such individuals are questioned may help them emphasize certain facts as opposed to others. Once witnesses have committed themselves to a version of the facts, either completely on their own, or with some subtle help from the questioner, there is a good chance that they will stick by this version, because they do not want to appear to be vague, uncertain, or inconsistent later. An investigator who takes such a course of action must be extremely careful, however. You are taking certain risks not because your conduct is illegal or unethical, but because a witness who needs subtle pressuring to state a version of the facts in a certain way is probably going to be a weak witness at trial or at an agency hearing. On cross-examination, the witness may fall apart. Left bracket section D. Sources of evidence/sources of leads. As we have seen, evidence is anything that tends to prove or disprove a fact. Two major categories of evidence are pearl evidence oral and tangible evidence physical. Exhibit 9.2 presents a partial checklist of some of the standard sources of pearl and tangible evidence or leads to such evidence. Of course, once evidence is identified, it often becomes its own lead to further evidence. Pearl evidence, oral evidence, tangible evidence, evidence that can be seen or touched. Physical evidence. Exhibit 9.2 checklist of the standard sources of evidence and leads for internet leads. See on the web at the end of the chapter. RCM:*H statements of the client. Use of alias documents the client brings or can obtain. Bureau of Vital Statistics and Missing Persons information from the attorneys involved with court records the case in the past. Workers' compensation records. Accounts of eyewitnesses. Office of politicians. Hearsay accounts. Records of Better Business Bureaus and interrogatories. Depositions. Other discovery. Consumer groups. Devices. Letters requesting information. Telephone book. Pleadings such as complaints filed thus far in Pope Directory, the case reverse directory. Newspaper accounts. Interviews with newsboat register reporters. Many public libraries have online automobile registry. DMV. Media indexes. You can check county assessor for real property. Notices in the media requesting information. Tax assessor's office. General records of municipal, state, and federal county election records. Administrative agencies. Post office record of forwarding addresses. Business records such as canceled receipts object to be traced, such as an auto. Employment records including job applications. Credit bureaus. Photographs. Reports of investigative agencies. Hospital records. Associations. Trade, professional, etc. Informers, or the town gossip. Who's Who directories. Surveillance of the scene. Insurance company. Clearinghouse reports from the police and other law. Standard and Poor's register of directors and enforcement agencies. See Exhibit 9.3 Executives' fingerprints. Telling your problem to a more experienced school records investigator and asking for other leads. Military records. Shots in the dark. Information that may be voluntarily or involuntarily provided by the attorney for the other side. Left bracket section E. Gaining access to records. Often the simplest way to obtain a record or other information is to ask for it. See for example, the sample letter requesting information in Exhibit 12.2 in Chapter 12. Gaining access to some records, however, can sometimes be difficult. There are 4 categories of records you may need to examine. 1. Those already in the possession of a client or an individual willing to turn them over to you on request. 2. Those in the possession of a governmental agency, for example, SEC Exhibit 9.3, or of a private organization and available to anyone in the public. 3. Those in the possession of a governmental agency, or of a private organization, and available only to the client, or to the individual, who is the subject of the records. 4. Those in the possession of a governmental agency, or of a private organization, and claimed to be confidential, except for in-house staff. Obviously, there should be no difficulty gaining access to the first category of records, unless they have been misplaced, or lost, in which event the person, who once had. Exhibit 9.3 Request for copy of peace officer's accident report. Date of request. Claim or policy. No request for copy of peace officer's accident report. Please submit in duplicate. Statistical Services, Texas Department of Public Safety, P.O. Box 15999, Austin, Texas 78761-5999. Enclosed is a check less than money order, payable to the Texas Department of Public Safety, in the amount of $1 for check service desired. D. Copy of peace officer's accident report, $4 each. D. Certified copy of peace officer's accident report, $8 each for the accident listed below. Please provide as accurate and complete information as possible. Accident date, month, accident location, day, year, county. Was anyone killed in the accident? City if so, name of deceased. Street or highway investigating agency, and/or officer's name if known, driver's full name, driver information if available, date of birth, Texas driver, license, no address. Texas statutes allow the investigating officer 1 day in which to submit his report. Requests should not be submitted until at least 10 days after the accident date to allow time for receipt of the report. The law also provides that if an officer's report is not on file when a request for a copy of such report is received, a certification to that effect will be provided in lieu of the copy, and the fee shall be retained for the certification. Mail to mail address, city state requested by. Phone #zip. Possess